I want to take a moment to explain what we're watching at the United States Supreme Court as Donald Trump uses a strategy of trying to press the Supreme Court into ruling for him by doing it with the shortest path, an emergency application. There are 10 emergency applications being sought by Donald Trump. 5 have been ruled on, and they are the worst kind of justice. As Justice Kagan wrote just a couple of days ago in one of her dissents, if you're using the emergency docket, it is by its very nature bare bones briefing with no argument and little time for reflection. Does that sound like the most major issues in the confrontation between the executive branch and the rest of the branches of government should be done on a bare bones record, no argument, leaving little time for reflection? But that is exactly what's happening as Donald Trump purposely avoids the merits docket, where 60 or 70 cases a year get decided, some of our most seminal ones, and take on the Supreme Court on procedural issues on a fast-paced shadow docket. It is the exploitation of the shadow docket, and it feeds into the natural tendencies of the Roberts Amy Coney Barrett court to not have confrontation with Donald Trump. And when you have a group that's going to allow themselves to be bullied by Donald Trump, he's going to take full advantage of it. You're here taking full advantage of Legal AF. I'm Michael Popok. Let's jump into the strategy that's on full display in broad daylight, where Donald Trump is purposely using the Shadow Docket Express in order to basically have his will at the United States Supreme Court. Now, there's 2 different ways. Effectively, there's 2 different pathways to have a case heard at the United States Supreme Court. The way that we normally talk about it is what we call through the merits docket, where the court has received a writ of certiorari asking for Supreme Court review. They get thousands of them a year, and the Roberts Court historically takes about 60 to 80 cases total. That's it. Other courts in the past, much harder working, they took 100 cases or more. Roberts Court, as the Chief Justice, 60 to 80. Writ of certiorari granted. There's full briefing, meaning 50 to 60 page briefs by both sides, legal argument, proper jurisprudential debate happens. Maybe some friends of the court on either side decide they want to be heard, so they ask for permission to file what's called amicus briefs. The amicus briefs come in. You've got a stack on both sides, on either side of the scale of justice. And then we have oral argument, which happens 3, 4, 6 months later. Full oral argument. All the judges and justices get to ask their questions, and from there, the clerks that work, who are law students or lawyers that work for each judge, they start writing memos depending upon who's in the majority and who's in the minority after a caucus where the Supreme Court gets together and says, hey, let's do a vote count. Who's for or against the appellant, the leading party, or the appellee, the party that is defending against the appeal. That's the normal method. Once you do the vote count, who's ever the senior judge in the majority writes the opinion. That's not what's happening here. What's happening here is the exploitation by the Trump administration of the shadow docket. What's a shadow docket? A shadow docket is you don't have the ability to, or you can't file the final appeal. Your case is not over. Your case just began. You're only in the temporary restraining order or preliminary injunction phase at the beginning of the case. The record's not complete, but you've gotten an order of a judge, in Trump's case, that you don't like, a nationwide injunction, a ruling that you've done something unconstitutionally. You violated the Administrative Procedures Act. You violated somebody's First Amendment right. You don't like that, so you want to take an appeal. So you go generally to the first level of appeal just above the trial court in the circuit where you're operating. So if you're in D.C., you go to the D.C. circuit. If you're in California, you go to the Ninth Circuit, and so on. So you go there, and if you're Trump, you lose 2-1, 3-0. You've lost. Now you take an emergency writ, emergency application for relief to block whatever the judge has just done below that's been affirmed by the intermediary appellate court. And the first person this is why it's called the shadow docket. The first person that rules on it is the justice that's assigned to that particular circuit. Every justice has a circuit. Some have multiple circuits. Blue state circuits are headed by the 3 liberal moderates on the bench, and the rest are headed by the MAGA right. Chief Justice Roberts, he has the prerogative. He is the first justice to handle emergency applications coming up from D.C. and Maryland and so on. So a lot of these are involving Roberts. They have the prerogative to reject or deny the application without consulting the other 8 on the Supreme Court. I got this. I'll make the ruling. But because these implicate with Trump these weighty issues of the collision, constitutional crisis between the executive branch and the other branches of government, generally as a matter of course, as a institutional process, that justice refers it to the full 9. If 5, what happens? They get it. Now the briefing is very skimpy as opposed to the merits. And this is what Trump's taking advantage of. The briefing consists of the application, which could be 10 or 15 or maybe 20 or 30 pages. That's it. Then the judge or the justice looks at it, maybe Roberts, maybe somebody else, and says, this is sort of interesting. I'm going to administratively stay whatever happened below to give us a little bit more time to get more briefing in. It won't be full briefing, but more briefing. And they enter an administrative stay generally. They don't have to, but they do. Then they give the other side a 2, 3, 5 days to file their opposition paper. So now you just have 2 pieces of paper, and they're very skimpy because the record below developed by the trial court is very skimpy. There's no depositions by this point. There's no questions and answer under oath, no interrogatories, questions and answers under oath in writing, no real document exchange, no fulsome exploration through the discovery process of the issues. None. It's a tiny little record with a tiny little set of briefing, and now they get it. Now they got the 2 pieces of paper. And you might be thinking, let's have oral argument. All those hearings we've heard so much about. No, it almost never do they hold oral argument. Almost never. I think they did on a fast track in Bush versus Gore to decide who the president was going to be. But other than that, you don't normally see oral argument. Now they do the internal counting to see if who's got 5 votes. And if there's 5 votes to grant the application or not. So the clerks start running around writing memos on behalf of their justices and circulating them. And then they're doing some counting. And then, okay, do we have 5 votes? Okay, we got 5 votes. And they issue what's called a per curiam, usually unsigned decision. Sometimes it could be signed by one particular person. But on this very, as Kagan said, very skimpy record. No argument, bare bones, no time for deliberation. Moves very, very quickly. The Supreme Court is supposed to be the most deliberative body. They're supposed to take their time, weeks, months, years to decide issues. Not here. And that's what Trump's taking advantage of. He's bull rushing the Supreme Court, and they're letting him. And then when he gets there, he's got 10 applications, more than the Biden administration almost combined filed. He's got 10 applications. 5 have already been decided, and he's winning most of them. He's because I believe, as my theory here, and my posit, is that he's doing it on purpose so that there's no real time for briefing, no real time for oral argument, and it's just about vote counting. And they've got a reliable 5 votes to restrain these federal judges, trial court judges below on a regular basis. He knows he's got his 5. His 5 are going to be, let's start with the base, right? We're making a recipe. Gorsuch, Kavanaugh, Alito, and Thomas. Solid 4 to push back against lower court federal judges. They don't like nationwide injunctions, at least when the Democrats do it. They don't like too broad a finding or ruling. They don't like the judge finding that a party has standing, meaning the ticket to the courthouse, by finding they have a special injury when they don't have that special injury. So 4 votes are almost always going to vote for Donald Trump. The question is, how do you count to 5? You got to get either Roberts and or Amy Coney Barrett, and they keep flipping. But one of them is joining the 4 on a regular basis to give Donald Trump the majority of the wins. Sometimes it's Amy Coney Barrett, sometimes it's Roberts, and sometimes it's both. They are the swings. They are the swings They are the hub around which this United States Supreme Court wheel is circling, is rotating. Okay. On the other hand, there's 3 votes on the Democratic wing of the Supreme Court, but they got to get 2, both Roberts and or Amy Coney Barrett or somebody else, which they'll never get, to join them. So we got to run the table and bat 1,000 and get both 2 judges. They only need 1. Now you see why Trump is trying to use the exploitation method of the emergency application. Now, he got a taste for it during his first administration. In his first administration, he had 41 emergency applications. That's separate and apart from the 40 or 50 or so cases a year on merits. Bigger briefing, more robust record, more oral argument, oral argument, and then ruling. Let's say half of those deal with the United States government in some way. So he's over there on the merits, and that's where our major cases usually come from. But of the 41 cases that he had in the first, look at the math. He's already 25% into his 4 years. 41 emergency applications in the first term for Trump. He won 28 of them. That's a pretty good batting average. And he learned there, and through his new Solicitor General, John Sauer, that this is the path for him. He needs to thread that needle of emergency, and they're all emergencies of his own making. If you really look at the applications, they're not emergencies at all. But he knows he has a willing 4 and maybe 5 to reverse course from the trial court level, and the path to do that is through pressuring them and using a fire hose to go after the Supreme Court in its weakest point, the emergency shadow docket route. And so we need to be up in arms about it. And we need the 3 moderates on the Supreme Court to argue more against the use of the shadow docket. And because they're exploiting the heck out of it. And in response, the Supreme Court, the 5 are trying to find ways, don't hit me, Daddy. Not again, Daddy, not to have confrontations with Donald Trump. And so they're finding procedural exit ramps. You almost had the injury necessary for standing, but not quite. So we're going to deny this motion. We're going to block the lower court's judgment. The venue. You filed. Oh, so close. Should have been filed in Texas, not in DC. Sorry, block. No. Wrong courthouse. No, immigration's down the street. Not Article 3 judge, immigration judge. Blocked. See? This is what they're doing. So they don't have to get to, that's why you're not hearing these great pronouncements about the merits of a case. All you're hearing is standing, venue, jurisdiction, all ticky-tack procedural technicalities as they try to avoid a direct confrontation with Donald Trump. But by doing so, of course, they're emboldening Donald Trump, and they're giving him the green light to do all the things he wants to do in immigration, funding, personnel, and the rest. And now we're going to see about war powers as we continue to follow it right here on Legal AF. Next time, you'll see me. It'll be here on Legal AF, the YouTube channel. Hit the free subscribe button. We got a brand new Blue Sky account. We'd love a subscriber base to grow. We just launched it today at Legal AF. What else? Go on Blue Sky for up-to-the-minute updates that we're going to do there as well. Join our community there. Hit the subscribe button. That really helps us continue to grow what we're doing here. And then come over to Legal AF, the YouTube channel, and Legal AF, the podcast, over on the Midas Touch Network and wherever you get your audio podcast from. We're at number 11 in the world in podcast. So crazy. Can't even believe I just said that out loud. We want now that we're there, we want to get to number 10 and above and join our brothers at number 1. Until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.